De rechtbank.
All rise.
Neemt u weer plaats.
Please be seated.
De zitting wordt hervat.
We're resuming the hearing.
De bereikbaarheid van de
Apparently there were some problems with the live stream,
voorzien.
but the problem seems to have been solved.
Ik zal verder gaan bij waar ik
I shall
gebleven
proceed
was.
where I left off.
Ik heb net iets gezegd over de positie
And I just talked
van de
about the
verdachte in
position
het Nederlandse strafproces.
of the defendant in the Dutch
En ik heb iets gezegd
criminal
over de
proceedings, and I
positie
said something
van
about the position
slachtoffers en nabestaanden in
of
het Nederlandse strafproces.
victims and next of kin
En die
in the
posities die
Dutch
zijn
criminal
verschillend.
proceedings. And these positions differ.
En ik merk op dat de
I would like to
wetgeving
highlight
betreffende de positie
that
van slachtoffers of
legislation with
nabestaanden
respect to the position
de
of
afgelopen
victims or
jaren
next of
voor een steeds
kin,
duidelijker en sterkere positie
and
in
this
het
has become
strafproces
clearer
heeft
and clearer over the
voor
past few
slachtoffers
years,
en
has led to a clearer position and a stronger position in the criminal
In
proceedings
de
for
praktijk van het
victims and
strafproces
next
kan
of
dit
kin.
leiden tot situaties
In practice, in a trial,
waarin
this can
slachtoffers
lead
of
to
nabestaanden
situations in
zich via
which
het spreekrecht
victims or next of
nadrukkelijk
kin,
richten tot een verdachte die terecht staat,
exercising their right to address the court, they can
terwijl de rechtbank nog niet heeft
explicitly
geoordeeld
address the
over de
accused
vraag
who's
of
standing
er sprake
trial,
is
whereas the court has not
van een
yet reached an
strafbaar
opinion as to
of een
whether
strafbare verdachte.
a criminal offence has been committed or whether the accused is punishable.
En het is van belang om onder ogen te
And it's
zien
important to
dat bij
realize
betrokken procespartijen
that
in
in the
deze
parties
strafzaak
in these
sprake is
proceedings,
van uiteenlopende rollen en
there are
belangen.
very varying roles and interests.
Een verdachte en zijn raadslieden
A defendant
hebben een
and
andere rol,
his
een
legal
ander
counsel
belang
have a
dan
different
de
role
nabestaanden.
and a different interest than the next of kin.
Procespartijen zullen daarom
Parties in the
op
proceedings,
verschillende
therefore,
manieren naar het dossier
will have
in
different
deze zaak
perspectives
kijken.
on the case and the case file.
Dat betekent dat partijen ook
And this means that
parties
parties
standpunten kunnen
will
innemen
may take
die door
positions
anderen als
that
vervelend of
others
zelfs
may
kwetsend
perceive as being
kunnen
annoying
worden
or even
ervaren.
painful.
Toch is het voor een onpartijdig
Nonetheless,
en eerlijk onderzoek
for an
van belang
impartial and
dat
fair
deze
hearing,
standpunten
it is important
kunnen en mogen
that these
worden
positions
ingenomen.
may be taken and can be taken.
Uiteraard moet iedereen de algemene
Obviously,
fatsoensnormen in acht nemen.
everyone should respect the general standards of decency.
Indien iemand die in deze zittingszaal aanwezig is
If
bij de
someone present in
bespreking
this
van het dossier
courtroom, when
op enig
the
moment
file is
moeilijk
being
vindt
discussed at
bepaalde
some
zaken of
point,
standpunten
finds
te
it very
horen,
difficult to listen
dan
to
kan hij of zij
certain
desgewenst
matters
de zaal
or
tijdelijk even
positions, this person,
zonder
if
daarbij
he or
overigens
she
de orde
so
te
wishes,
verstoren.
can temporarily leave the room without disturbing the order.
In deze zaak zal de rechtbank
In this
zorgen dat
case,
aan de positie
The court
en de rechten van
will
verdachten
make
recht
sure
wordt gedaan. In die zin
that it
dat
will do
sprake zal zijn
justice
van een
to the
eerlijk
position
proces.
and the rights of the accused, and
Hetzelfde
that in that
geldt
sense
voor de
there will
positie
be a
en de
fair
rechten
trial.
van
And the same
nabestaanden
applies to the
van de
position and the
slachtoffers
rights
in
of
deze
next of
strafzaak.
kin and victims
In
in
die
this
zin
criminal case,
dat zij de
in the
gelegenheid
sense
krijgen
that they will be given
in
the
de zittingszaal een
opportunity
spreekrecht uit te
to
oefenen
address the
en
court in
vorderingen
the
tot
courtroom
schadevergoeding
and to
in te
file
dienen.
claims for compensation.
En de rechtbank vraagt daarom aan ieder om elkaar met
And therefore the
respect
court would
te bejegenen.
urge each and every one of you to treat each other with respect.
Het neerstorten van vlucht MH17
The
op
crash
7
of
juli
flight
2014
MH17 on July 17,
heeft tot de dag van
2014,
vandaag
to this date,
geleid tot
has
een
led
omvangrijke
to a
stroom
large amount
van berichten in de
of
media.
reports in the media.
Die berichtgeving zal niemand zijn
These
ontgaan.
reports won't have escaped anyone.
Ook de rechtbank niet.
They haven't escaped the court either.
Het neerstorten van vlucht
The crash of
MH17
flight
heeft op
MH17
veel terreinen discussies ontketend
has fired
in de
debates
zoektocht
in very many
naar het kunnen
respects
plaatsen
in the
van
quest
verantwoordelijkheid.
towards establishing responsibility.
Wat daar ook van zij,
In any
in
case,
deze
in
strafzaak
this criminal
staat het
case,
resultaat van het strafrechtelijk onderzoek
we're focusing
centraal.
on the result of the criminal investigation.
Het Openbaar Ministerie heeft een procesdossier
Public prosecution
samengesteld
has
en
compiled
ter
a
lastenlegging
file
opgesteld,
of the proceedings and
waarin op
drafted
dit
an
moment 4
indictment
individuen
in which at this
ervan
point in
worden
time
beschuldigd
4
een concreet
individuals are
omschreven
being
strafbare
charged
rol te hebben gespeeld
of having
bij het
played
neerhalen van
a
MH17.
criminal role which has been specifically described
Nou, die terlastenleggingen
in
en dat dossier
causing the
worden op
MH17
deze
to
zitting
crash.
besproken.
And that indictment and this
En
file
dat
will
vormt
be
het kader
discussed at this
voor de
hearing.
bespreking
And that
en
constitutes the
beoordeling van deze
framework
strafzaak.
for hearing and adjudicating this criminal case.
De rechtbank zal in het kort
The
uiteenzetten
court
hoe in Nederland
will
het
shortly
strafproces
describe
verloopt.
criminal proceedings in the Netherlands and how they are
Dat is vooral
conducted.
van belang
And this
vanwege
is
de
particularly
grote
important
internationale
with respect to
belangstelling
the
voor
large
deze zaak.
international interest and attention in this
Het
case.
verloop van een zitting in een Nederlands
The
strafproces
course of a hearing
het wetboek
in
van
the Dutch
strafvordering
criminal
voorgeschreven.
proceedings has been laid
En dat
down
leidt
in
voor
the
de
Dutch
meeste
Criminal
strafzaken
Code of Procedure.
tot een gelijk
And for most criminal
zittingsverloop.
cases, that leads to a well-balanced conduct of proceedings.
De rechtbank stelt eerst vast of er
The
al dan
court
niet
will
een
first
verdachte is
determine
verschenen.
whether or not a defendant has appeared.
Indien dat het geval is,
And should that be
vertelt
the
de officier
case,
van justitie
the public
waarvan hij wordt
prosecutor
verdacht.
will present the accusation.
Dat heet de voordracht.
This is called the presentation.
Daarna wordt het
The
dossier met de
accusation.
verdachte besproken.
After
Er
that,
worden daarover
the file is
vragen aan
discussed
hem
with the
gesteld.
accused and questions can be asked
De
to the
verdachte is niet
defendant.
verplicht om
The
vragen te
defendant
beantwoorden.
is not obligated to answer any questions.
Indien er geen verdachte en geen gemachtigde advocaat namens hem zijn
If
verschenen,
no defendant
en
has
de verdachte
appeared
wel
or
op de
no
juiste wijze
authorized
is
counsel on
gedagvaard,
his behalf,
dan kan
and
de
if the
rechtbank
defendant has been
zogenaamd
duly
verstek
summoned,
verlenen.
then the court can try in
Dat
absentia,
betekent dat de zaak
which means
wordt
that the
behandeld
case will be
buiten
heard
aanwezigheid van de
without
verdachte.
the defendant being present.
Ook in dat geval
In such a
draagt de
case,
officier van justitie de
The
zaak
public
voor
prosecutor will also
en zal
present
de
the
rechtbank de inhoud
accusations,
van het dossier
and the
bespreken.
court will discuss
Maar daarover
the
kunnen dan geen
substance of
vragen
the
aan de
file,
verdachte
but no
worden
questions
gesteld.
will then be asked to the defendant.
Anders dan in veel andere
As opposed to
landen
many
is
other
in het
countries,
Nederlandse
in the Dutch
strafrechtssysteem
criminal
niet gebruikelijk
law
om
system,
alle
it's
getuigen
not common
of
practice
deskundigen
to
in een
examine
strafzaak ten overstaan
witnesses
van de rechtbank te horen.
or experts
Al kan
in a
dat
criminal
natuurlijk wel.
case before the court. It is, however, possible.
De Nederlandse strafrechter behandelt een
The
strafzaak
Dutch
vooral op
court in
basis
criminal
van
cases will
schriftelijke
hear a
stukken.
case particularly on the basis of written
In
documents.
Nederland vindt de strafproces
And in the
namelijk
Netherlands,
plaats,
the criminal
voornamelijk
proceedings will
plaats op
take
basis
place
van het strafdossier.
essentially on the basis of the case file.
Behalve het bespreken van dit dossier,
Besides
komen ook de
discussing the
persoonlijke
file,
omstandigheden
personal
van de
circumstances
verdachte aan de
of the
orde.
defendant will also be addressed.
Slachtoffers van strafbare feiten
Victims of
krijgen
criminal
de gelegenheid
offences will be
een
given the
spreekrecht uit te
opportunity
oefenen
to exercise
en
their
ze
right to
kunnen
address the
vorderingen
court,
indienen tot
and they can
schadevergoeding.
file claims for compensation.
Nadat dit allemaal is gebeurd, krijgt de officier van justitie de
Once all this has been
gelegenheid om
done, the
standpunt
public
in te nemen.
prosecutor will be given the opportunity to
In
present
zijn
his
requisitoor
position.
draagt
And
hij zich
in
uit
his
over de
statement,
vraag
the public
of het
prosecutor will address the
lastiggelegde
question
feit
as to
bewezen
whether
kan worden verklaard,
the offences as charged can
of
be
dat een
considered proven,
strafbaar feit oplevert,
whether these offences
of de verdachte
constitute
strafbaar is,
are a punishable
Zo ja,
offence,
welke straf
and
moet worden
whether the
opgelegd.
defendant is punishable, and if so,
Er kunnen ook nog andere
which
aspecten aan de orde
punishment
zijn
should be
waarover
imposed,
de
and that there
officier
could
van
be other
justitie een standpunt
aspects
inneemt.
on which the public prosecutor
Bijvoorbeeld
can take a
over
position.
vordering van schadevergoeding,
For instance, with respect to claims for
moet gebeuren
compensation
met in
or
beslag
what needs to be
genomen
done
voorwerpen.
with seized objects, for instance.
Daarna krijgt de verdediging, de
Subsequently,
naarsdiende van de
the
verdachte, de
defense's
gelegenheid
legal counsel will be given the
standpunt over
opportunity
deze
to
onderwerpen te
to
bespreken
present their
en te
position
bepleiten.
with respect to these matters and to argue the case.
Een slachtoffer of nabestaande kan zich
The
vervolgens
victim
nogmaals
or the next
uitlaten
of
over
kin
ingediende
can once again
vorderingen.
explain his position with regards
En daarna
to
zijn
claims for
officier van
compensation,
justitie en de
and
verdediging
after that the public
nogmaals in de
prosecutor
gelegenheid te reageren.
and defense will once again be given the opportunity to respond.
Ten slotte heeft de verdachte nog het recht om als
And
laatste
finally,
het woord te
the
voeren.
defendant is entitled
Daarna
to
wordt de zitting
have the
gesloten
last word.
En beraadt de rechtbank
After that,
zich
the
op de
hearing will be
uitspraak,
closed,
op het vonnis.
and the court will deliberate on the judgment,
Die
on the
uitspraak
ruling.
wordt op een later
And
moment,
this judgment
meestal na 14 dagen,
Is
uitgesproken
usually
op een
pronounced
openbare
at a later
terechtzitting.
point in time, usually after 14 days, at a
In deze
public hearing.
strafzaak
In this
zal de
criminal
rechtbank
case,
te zijner
the
tijd
court,
een
however,
langere
in
periode
due
dan
course,
14 dagen
will take
gebruiken
a longer
om tot een
time,
oordeel te
more
komen
than 14
en dat
days,
oordeel
in
in
order
vonnis
to
op te
present
nemen.
its judgment and to reflect it in a ruling.
Het voorgaande is het normale verloop van een zitting.
What I've just
Waarbij de
described is a
zaak
normal
direct
course of
inhoudelijk
events,
wordt
in
behandeld.
which in a case
In de
we
meeste
immediately
strafzaken worden op
proceed
deze manier
to hearing
behandeld.
the case on the merits.
En deze
And in most
werkwijze
criminal cases,
geldt
this
in
is the
beginsel
way
ook
the case is heard.
voor de strafzaak
And this
MH17.
method will, in principle, also apply to the
Maar niet
criminal
alle
case
zaken zijn bij de aanvang
MH17.
ervan gereed
But
voor
not
een
all
directe
cases
inhoudelijke
are,
behandeling.
at the beginning, already ready to be heard on the merits of the
Op
case.
dit moment
At
staan
this
we aan
point
het
in
begin
time,
van het
we're at the very
strafproces in
beginning
de zaak
of the
MH17.
criminal trial in the case of
Bij
MH17.
omvangrijke zaken vindt
In
meestal
large
eerst
and
een
vast cases,
zogenaamde
usually
regiezitting plaats.
we have a pre-trial hearing.
Vaak is in een grote zaak het dossier nog niet
In large
gereed.
cases,
Kan
very
het
often, the
voorkomen
file
dat
is
de
not
rechtbank,
ready yet, and it can
de
happen that
verdediging
the court,
of de officier van justitie
defense,
nog
or the
nader
public
onderzoek wenst.
prosecution still
Dat
needs
wordt dan
further
besproken op
investigation.
een regiezitting.
This then is discussed at a pre-trial hearing.
De rechtbank neemt een beslissing
The
op
court
verzoeken
then
die door de
takes a
verdediging
decision with regards
of
to
het
the
Openbaar
request put
Ministerie
forward
zijn
by
gelegd.
defense and/or public prosecution.
Maar het kan ook zijn dat de verdediging
But it
vindt
can also be
dat de zaak
that,
zelf
according
niet
to
moet
the
worden
defense,
besproken.
the case itself
De verdediging
should
kan
not be
namelijk het
discussed.
standpunt innemen
The defense
dat
can
de
take the
dagvaarding
position
nietig is,
that a summons is null and
dat de
void,
rechtbank
that the
onbevoegd
court
is,
has no jurisdiction,
of het Openbaar
or the
Ministerie
public prosecution
niet
has no
ontvangt.
right to prosecute.
Dat zijn zogenaamde
These are so-called
preliminaire verweren.
preliminary
Die kunnen
objections,
worden onderzocht
and they can be
zonder dat
examined
de inhoud van de zaak zelf aan de
without
orde komt.
addressing the substance of the case itself.
Indien de verdediging een dergelijk verweer wil
If the
voeren,
defense wants to
dan wordt dat
pursue
direct
such a
bij de
defense,
aanvang van de zitting aan de orde
it
gesteld.
has to be addressed at the
Nog
beginning
voor de
of the
voordracht
hearing,
van de zaak
even before the
van de officier van
presentation of the
justitie.
accusation on the part of the public
En dat
prosecutor.
moment wordt zo door de wet
And this is a point in
voorgeschreven.
time that is stipulated by law.
De reden daarvan is dat
And the
wanneer een
reason
dergelijk
is
verweer slaagt,
that if
de zaak
such a
daarmee ten
defense
einde is gekomen.
succeeds, that'll mean the end of the case.
En aan een inhoudelijke behandeling,
And it will also
dus de
mean
bespreking van het dossier en
that
alles wat daarmee samenhangt,
the discussion of the
wordt dan niet
file,
meer toegekomen.
the merits of the case will then no longer be discussed.
Zoals eerder gezegd, heeft
As I pointed
voorafgaand
out
aan deze
earlier,
zitting overleg
Prior to
plaatsgevonden
this hearing,
tussen de
there has been
verdediging en de
discussion
officieren van
between the
justitie.
defense and the public prosecution.
Er is een briefwisseling geweest tussen de verdediging, de
There's
officieren
been
van
correspondence
justitie en de rechtbank.
between the defense, public prosecution and the
De
court.
verdediging heeft daarbij te kennen gegeven
The defense has
nog
pointed
geen
out
standpunt te kunnen innemen
that it cannot
over de vraag
take a
of
position
zij dit
yet
soort preliminaire
on the
verweren
question as
zal
to whether
voeren.
or not it will file
Ook
such
zegt de
preliminary
verdediging nog
objections.
niet aan te kunnen
And the
geven
defense
of
has
er
also
onderzoekswensen
indicated
zijn
that it cannot point
die de
out at this
verdediging
point in
op de
time
terechtzitting wil
whether there are any
bespreken.
requests for investigation that they would like to
De
discuss
belangrijkste
at the
redenen hiervoor
hearing.
zijn dat de verdediging pas
The main
kort geleden
reason is that the
het omvangrijke
defense
dossier heeft ontvangen
only received the
en
case
dat zij,
file a short time
ook omdat
ago,
het dossier
and also because the
grotendeels in
file
Nederlands
is
is
essentially
opgesteld,
in Dutch.
dit nog niet
They have not
met haar cliënt hebben
had the
kunnen bespreken.
opportunity to discuss the file with their client.
Strikt genomen
Strictly speaking,
zou het strafproces dus
the criminal trial
moeten wachten
would have to
tot de
wait
verdediging
until the
voldoende is
defense is
voorbereid
sufficiently
om te kunnen
prepared
bepalen
in order to
of zij de
determine
genoemde
whether or not
preliminaire verweren
they would like to
wil
file
voeren.
the so-called preliminary
En
objections,
of de verdediging verzoeken heeft tot het doen
and
uitvoeren
also
van
whether the
nader
defense has
onderzoek.
any requests for further
En
investigation,
dat zou betekenen dat de zitting
And that
op dit
would
moment
imply
niet verder kan gaan.
that the hearing would not be able to proceed.
In de eerder genoemde briefwisseling
In the
tussen
aforementioned
de waarschuwing van de
correspondence
verdachte
between
Pulatov
legal counsel
de
of
officieren van
defendant
justitie
Pulatov,
en de
public
rechtbank
prosecution and
is
the
de
court,
mogelijkheid aan de orde gekomen
the possibility
hier
was
ter
discussed
terechtzitting
that here at the
nu vandaag
hearing
wordt beslist
today a
dat de
decision be
raadslid bij
taken
de aanvang van het
that
volgende
legal
zittingsblok
counsel at the start
in
of the
juni
next hearing
van dit
block,
jaar
that would be
de
in June
preliminaire
2020,
verweren mogen voeren.
they can file their preliminary
En ook
objections,
dat ze dan
and
verzoeken
also
tot nader onderzoek mogen doen.
that they can make requests at
Welke
that time
verzoeken
for
de
further
rechtbank
investigation,
dan
which
weliswaar
requests
zal toetsen
will then
op de
be
noodzakelijkheid
reviewed and
daarvan,
examined by the court
maar dat
in
de
order to
uitkomst van die
establish whether they're
toetsing
necessary, but the
niet wezenlijk
outcome
zal verschillen
of this examination
van
will
wat
not
met toepassing
fundamentally differ from what
van het
would be
zogenaamde
achieved by
verdedigingsbelang
applying the
zal
so-called
worden
interest of the defense.
En dat betekent dat als
And
de
that
rechtbank
means
moet
that if the
beslissen
court has
of
to
nog nader
decide
onderzoek moet worden verricht,
whether or not further
zij feitelijk
investigation
toetst
should be conducted,
of de
the
verdediging
court
belang
will
heeft bij
in
dit
fact examine whether the defense has
Hetgeen
an
een lagere
interest
lat
in
is
such an
dan
investigation.
de formele
And
toets.
this threshold is lower than the
Namelijk of het onderzoek
formal criterion,
noodzakelijk is.
namely whether or not investigation is
over
necessary.
deze punten is voorafgaand aan de zitting
Now, there's been
gecorrespondeerd.
correspondence prior to this
En dat heeft
hearing
geleid
on
tot
these
de
points,
uitkomst
and
zoals
this
ik
has
net
led
heb
to the
uiteengezet.
outcome that I just outlined.
En dat betekent ook dat ik nu
And that
eventjes
also
met
means
blik
that I
ben tot
will
de
now
verdediging en
look
tot de officier van justitie.
at the defense and public
Dat ik aan hem
prosecution,
wil vragen of
and
ik
I'd like to ask
hiermee
them
deze punten
whether I
over de
have
preliminaire
formulated
verweren,
these points on preliminary
na de voordracht
objections
zullen plaatsvinden.
correctly, that they will be taking place
bespreken
after
van
the presentation of the
onderzoekswensen die dus op
accusation,
een later moment
and the
zullen
discussion
plaatsvinden.
of the
En dat
request for
daarbij het
investigation will
zogenaamde
also be
ruimte
discussed
wordt toegepast.
at a later point
Of
in
het
time,
juist
and
heb
that therefore we
geformuleerd,
will be
samengevat.
applying a broader criterion. So the
dat
question
dan
is whether
onderwerpen zullen
I have
zijn
summarized that
die
correctly,
in de volgende
and that these will be
zittingsperiode
matters
van
that will be
8
discussed in the next
2020
hearing
aan de orde
period
zullen komen.
as per June 8, 2020.
Ja,
Correct.
dat is correct.
That is correct.
Ja. En de officieren die geven ook aan dat dat
Prosecution
correct
has also indicated that
is. En
that
nu
is
u allebei
correct.
aangeeft dat ik dat correct
Now
heb
that you have all
verwoord,
indicated that I have
kan ik zeggen
formulated
dat de
this
rechtbank
correctly, I
zich
can
ook
inform you that the
op voorhand
court
in overleg met u in deze aanpak heeft kunnen vinden.
agrees with
Dat
this
betekent dat hier die
approach,
beslissing
and
over
that
die
means
punten,
that hereby this
die
decision
dan
on these
ook ter
points
terechtzitting zijn genomen.
have been taken at the hearing.
En het gevolg daarvan is dat de zitting op dit
And the
moment kan worden
consequence
voortgezet.
of that is that we can proceed with the hearing at this point in time.
Ja, en dan kom je nu eigenlijk aan het echt formele
Well,
moment.
this takes me to the real, actual
dat we gaan kijken
formal
of er
moment
verdachten
in
zijn
which
verschenen.
we have to
Ja,
check
de
and
zitting
see
staat
whether
deze
the
dagen
defendants have appeared.
in
And
het teken van het
the hearing
inventariseren van de stand van
is
zaken,
going to
het
focus the next few
opsporingsonderzoek
days on the state of
en het
play,
bespreken van de
taking
verdere
stock
planning
of
van de
the
strafzaak.
situation, of the investigation,
In deze
and
strafzaak
the
zijn
planning
4
of this
verdachten
criminal trial.
gedagvaard.
In this criminal trial, 4
De zaken van
defendants
deze
have been
4
summoned.
verdachten worden
In the
niet
cases of these
gevoegd behandeld.
four defendants are not
De
being
rechtbank
joined.
zal de zaken van deze 4
court
verdachten wel gelijktijdig behandelen.
Will hear the cases of these
dat
4
betekent onder
defendants
andere
simultaneously,
dat als een verdachte
however,
ter
and that
terechtzitting
means,
aanwezig
amongst other
is,
things, that if
dat
a
zijn verklaring
defendant
alleen
appears
geldt
before the
in zijn
court,
eigen zaak.
his statement will only apply in his own
Verder
case.
betekent het ook
And
dat
it
het
also
bespreken van
means
het dossier door de
that
rechtbank
the discussion of the file on the part of the court
plaatsvindt,
will take place simultaneously for all cases,
tenzij dat anders wordt vermeld.
unless otherwise stated.
En de rechtbank zal nu overgaan
And the
tot
court will now
de
proceed
formele aanvang eigenlijk
to
van
the
de vonnis ter
formal
terechtzitting.
start
En eerst
of the court
vaststellen
hearing,
ja, wie er zijn
and
verschenen ter
will first
terechtzitting.
confirm who has appeared
En
at the
ter
court
terechtzitting
hearing.
zijn geen van de verdachten verschenen.
None of the
Dat
defendants
kunnen
have
we hier
appeared at the
vaststellen.
court hearing. We can confirm as much
Dan begin
here.
ik met de verdachte
Now, let me start with the defendant Oleg
Pulatov.
Gildachevich
niet
Pulatov.
verschenen.
He has not appeared.
Hij is geboren op 24
He
juli
was born on July
1966
24, 1966 in the Soviet Republic, Tajikistan.
en hij is woonachtig
And he
in
lives
Ulyanovsk in de
in
Russische Federatie.
Ulyanovsk in the Russian Federation.
Nu hij niet is verschenen,
Now that
zal
he
de
has not
rechtbank eerst
appeared,
moeten
the
vaststellen
court will first have to
of de
determine
dagvaarding
whether
aan Pulatov
the writ of
op de juiste
summons
wijze is
has
betekend.
been duly served to Mr. Pulatov.
De officier van justitie
Public
heeft een
prosecutor
procesverbaal opgesteld over de wijze van
Has
uitreiking
drawn
van
up
de
an official
dagvaarding
record
aan Pulatov.
on the way the summons was presented to Mr. Pulatov.
Daaruit blijkt dat de rechtercommissaris
And this
17
shows that the
oktober
investigating
2019
judge on October 17, 2019 provided an address to the public prosecutor,
Pulatov volgens de
the
Russische
address
Federatie
at which
stond ingeschreven.
Mr. Pulatov was registered according to the Russian
Die
Federation.
informatie
This
heeft de
information
rechtercommissaris verkregen in het kader
was
van de
obtained by
uitvoering
the
van haar
investigating
rechtsonderzoek
judge in the
aan de
context of the
Russische
execution
Federatie om
of a
een brief
mutual legal
aan
request for legal
Pulatov
assistance
uit te reiken.
to the Russian Federation in order to
opgegeven
serve
adres,
the letter
zoals
to
ik net
Mr.
al zei,
Pulatov. And the
in
address
Ulyanovsk in de
that
Russische
was given
Federatie.
was this address that I just referred to in Ulyanovsk in
Met
the
een
Russian
rechtsonderzoek
Federation.
van 18 oktober 2019
With an
is aan de
MLA
Russische
dated
autoriteiten
October
verzocht
18, 2019, the Russian authorities
in de
were
Nederlandse
requested
en in de
to
Russische taal
present
aan de verdachte
the
uit te
defendant
reiken.
with a writ of summons in the Dutch and Russian
28
language.
oktober 2019
On October
is dit
28,
rechtsverzoek
2019,
overhandigd aan het Russische pakket
this
van de
request for legal
procureur-generaal.
assistance was handed over
Volgens een
to
later
the
bericht
Procurator's
van het
office,
Russische pakket
Procurator
is dit
General's
verzoek
office
doorgezonden
of the Russian
aan
prosecution.
het Russische
And
ministerie
according
van
to
Justitie.
a subsequent message of the Russian prosecution office, this request was forwarded
Vervolgens
to
werd
the
een brief
Russian
ontvangen
Ministry
door
of
de
Justice.
rechtercommissaris
Subsequently, a
gedateerd
letter
16
was
oktober
received by the
2019
investigating judge
van de
dated
Russische
October
advocaat
16,
mevrouw
2019,
Kutina.
of the Russian counsel, Ms. Kutina,
Zij schreef dat zij
She
de verdachte
wrote
Pulatov
that she was
vertegenwoordigde.
representing the defendant, Mr. Pulatov.
Zij deelde namens de verdachte mee dat hij niet betrokken is
She
bij het
stated
neerstorten
on
van een
behalf
vliegtuig.
of the defendant that he was not involved
En zij
in the
schreef
crash
verder
of the
dat de
aircraft.
verdachte
And furthermore, she
een advocaat
wrote
wilde zoeken
that the defendant
die
wanted to
bevoegd
look
zou
for
zijn in Nederland in rechten bij te
legal
staan.
counsel that would be competent to represent him in the Netherlands.
Officier van Justitie heeft mevrouw Kutina daarvoor
The public
verwezen
prosecutor referred
onder
Ms.
andere de
Kutina,
Nederlandse Orde van
amongst others, to
Advocaten
the Dutch Bar Association
en de Nederlandse
and
Vereniging
the Dutch
van
Association of
Strafrechtadvocaten.
Defense Lawyers.
En bij een e-mail van 19
And by
december
means of an email
2019
on December 19,
heeft de officier van
2019,
Justitie de
the public
dagvaarding
prosecutor
in het Nederlands en het Russisch
sent
aan mevrouw
Ms. Kutina the
gezonden.
writ of summons in Dutch and in Russian.
Op 3 februari
On
2020
February 3,
ontving de officier
2020,
van
the public
Justitie van het
prosecutor
Russische ministerie
received
van
from the
Justitie
Russian
het
Ministry of
bericht
Justice,
dat
received a
uitvoering was
message
gegeven aan het
that
rechtshulpverzoek.
the request for mutual legal assistance had been
Daarbij
executed.
was een beschikking van de rechtbank
A court
op
order
Ulyanovsk
of
gevoegd,
the Ulyanovsk court had been
waarin
added to
stond
that,
vermeld dat
stating
Pulatov
that Mr. Pulatov,
23 januari
on the
2020
23rd of
Russische
January
rechtbank is
2020,
verschenen
appeared before the Russian court,
en de in het rechtshulpverzoek genoemde stukken aan hem zijn uitgereikt.
and that the documents referred to in the MLA were served to him at that point in
De
time.
verdachte Pulatov is vandaag niet verschenen ter terechtzitting.
Defendant Mr. Pulatov has not appeared before
Uit
the
de
court
stukken
today.
die ik zojuist heb
The documents that I
besproken,
just
komt naar
referred
voren
to show
dat de dagvaarding aan
that the
Pulatov
writ of
is
summons
uitgereikt.
was served to Mr.
De
Pulatov.
verdachte Pulatov is dus op de hoogte
Defendant
van de
Mr.
verdenking
Pulatov
tegen hem
is therefore aware of the charges
en van
against
de
him
zitting van vandaag
and of today's hearing
en van de voortzetting daarvan bij de andere
and the
zitting.
continuation of the trial
En hij
during
kiest er
the other
kennelijk voor om
hearing
hier
blocks.
vandaag niet
And
aanwezig te zijn.
apparently he has decided not to appear before
Wel
the court
aanwezig.
today.
Zeg raadslid de heer Van Eyck en
Present.
mevrouw ten Doesgaten. En mijn vraag aan u is of u uitdrukkelijk bent
The
gemachtigd
legal counsel of
door de
Mr. Pulatov, my
Pulatov
question
om
is
hem
whether
ter
you've been
terechtzitting te
explicitly
verdedigen.
authorized
Ja.
to defend Mr. Pulatov at the hearing. The
Dank u
answer
wel.
is yes.
En gelet op die positieve
Thank you.
beantwoording is de conclusie
And so therefore the conclusion
de zaak
is,
tegen
given the
de
fact that
verdachte
you just
Pulatov
answered affirmatively,
tegenspraak zal
that
plaatsvinden.
the case against Mr. Pulatov will be taking place as an adversarial procedure.
Ik heb net geconstateerd dat ook de andere
I
verdachten
just
niet
noted that
verschenen
the
zijn.
others
En dat betreft Sergej
accused did not appear either.
Nikolajevich
They are Sergei
Dubinsky,
Nikolaevich Dubinsky,
geboren op 9 augustus
born on 9
1962
August 1962
in Donetsk in
in
Oekraïne.
Donetsk, Ukraine.
Zijn adres is
His address
in de provincie
in the
Rostov in de Russische
is the
Federatie
province
in het
of
dorp
Rostov,
Stepnoy.
the Russian Federation in the village of Stepnoy.
De andere verdachte is Igor
Another suspect is
Volodovich Girkin,
the
geboren
Volodovich
17 december
Girkin, born on 17 December
1972 in
1972 in
Moskou,
Moscow,
de
in the
Russische
Russian Federation,
En hij is ook in Moskou woonachtig.
and he resides in Moscow.
En verder Leonid
And then
Volodimirovich Tjatchenko,
Volodimirovich
geboren op 10
Tjatchenko,
januari
born on 10
1972
January
in de Oekraïne.
1972 in
En
Ukraine,
van hem is ook een adres bekend.
and his
in
address
de
is
Oekraïne,
known
in
as well
Donetsk.
in Donetsk, Ukraine.
Zij zijn niet verschenen.
They have not appeared
En ook heeft zich voorafgaand aan de zitting
prior
geen advocaat
to this
voor een
hearing.
van deze
No
verdachten gesteld.
counsel came forward for any of these
De rechtbank zal nu bespreken welke stukken zich
defendants
in
either.
het
The
dossier
court shall
bevinden
now discuss which
betreffende
documents
de betekening van de
are in the
dagvaarding aan
file
deze
concerning
verdachten.
the service of the writ of summons to these.
En ik zal eerst
defendants.
aangeven
First, I will
wat het
indicate
toetsingskader is waar de rechtbank
the
rekening mee houdt.
review framework that the court considers.
De kennisgeving van een dagvaarding aan natuurlijke personen
notification
geschiet door betekening.
Of
Dat
a
wil
writ of
zeggen,
summons to
De
natural
uitreiking
persona
van een dagvaarding,
happens through service. That means that the writ of summons
dat
is
het plaatsvindt
served
op de bij de wet voorziene wijze.
in the as provided
Indien
for
de
by law.
geadresseerde zich niet in detentie
If
bevindt
the addressee is
en
not
niet
in
als ingezeten
detention,
is ingeschreven
and
in de basisregistratie
is not
personen
registered
en van
in
hem
the key
geen
register
feitelijke woon-
of
of
persons,
verblijfplaats in Nederland bekend
and
is,
no actual
dan wordt de dagvaarding aangeboden
address or
aan
place
de
of
griffier van
residence
de
is
rechtbank
known in the Netherlands, then
waar
the
de zaak
writ of
zal
summons
dienen
is
tot het
presented
laatst heeft gediend.
to the clerk at the court in the district where
Indien
the
van de
case
geadresseerde een
will
verdachte
be
een
or
woon-
was
of
brought
verblijfplaats
forward.
in het
If
buitenland bekend
for
is,
an addressee
dan wordt de
an
dagvaarding
address or
door
place of
het
residence
Openbaar
abroad is
Ministerie,
known,
hetzij
then the writ
rechtstreeks,
of
hetzij door
summons
tussenkomst van de bevoegde buitenlandse
is
autoriteit of
sent by the
instantie,
public prosecution service either
voor zover er
directly
nog een
or
verdrag van toepassing is,
through the
met inachtneming van dat verdrag
competent foreign
aan de
authorities or
verdachte gezonden.
institutions to the extent a convention may apply
De
with
dagvaarding
regard to the
wordt
convention.
daarbij vertaald in de taal of een van de
The writ
talen
of summons
van het
is
land waar de
translated into
geadresseerde
the language or
verblijft,
one of the languages
dan
of the
wel in een
country
andere taal
where the
die
addressee
hij machtig
resides,
is.
or translated into a
Door die
different language
toezending
in
is
which
de
is
dagvaarding
proficient.
rechtsgeldig betekend.
This
En als datum waarop de
transmission
betekening
constitutes
plaatsvindt,
due
geldt de
service
datum
of the
van de
writ of
verzending van
summons,
de
and the
dagvaarding,
date of
waarvan
service
aantekening dient te
is considered to
geschieden in
be
de akte van
the
uitreiking.
date on which the writ of summons is sent, noting
Voorts geldt
the
dat uit de stukken slechts hoeft te
date
blijken
in the
dat de
memorandum of
tussenkomst
service.
is ingeroepen.
In addition,
En niet dat aan het gedane verzoek is voldaan.
Documents need to reflect only that the matter has been brought
Indien
before the
evenwel
court.
aannemelijk is dat de buitenlandse autoriteit of
If
instantie
it's plausible that the foreign authority or institution has not
behoort de
implemented
rechter het onderzoek ter
the request,
terechtzitting te schorsen
then
ten einde dat verzuim te
the
doen
court is
herstellen.
expected to suspend the investigation
Indien de
at
dagvaarding
the
van de
hearing
verdachte
to
van wie een
compensate
adres in het buitenland bekend
for
is,
this
rechtsgeldig
not
is
happening.
betekend
If the writ of summons
en de verdachte
has been served
nog geen
to
raadsman
a defendant
de
whose address
terechtzitting is
abroad is
verschenen,
known, and neither the defendant nor
dan
his
kan de
counsel
rechter,
appears
tenzij
in
er
court,
aanwijzingen zijn
then
van het
the court,
tegendeel,
unless there are
uitgaan
indications
van
to
het
the
vermoeden
contrary,
dat de
the
verdachte
court may
vrijwillig
presume
afstand heeft
that
gedaan
the
van zijn
defendant
recht
has voluntarily
om zijn
waived
tegenwoordigheid
his
te worden
right to be
berecht.
present at trial.
Ook indien van de verdachte geen woon- of
And
verblijfplaats bekend
if
is
no
en de dagvaarding
address or
overeenkomstig
place
de
of residence is known
toepassingsregels is betekend,
for the defendant,
mag de rechter
and
overgaan tot de
the writ of
berechting van
summons
de zaak.
has been duly served according to applicable rules, the court
Bij de
may
aanvang van een strafprocedure waarin de
continue
verdachte niet is
with the
verschenen,
trial in
moet
the
de
case.
rechter
At the
eerst de
start
geldigheid van de
of
uitreiking
criminal
van de dagvaarding
proceedings
onderzoeken.
for which where a
Indien
suspect
die
has
dagvaarding
not
niet op
appeared, the
geldige
court
wijze is
needs to
uitgereikt,
examine
dan spreekt de
first
rechtbank de
whether the
gültigheid van de dagvaarding uit.
writ of summons was duly served. If the
Indien die oproeping
summons
wel
was
geldig
not
is,
duly served,
dan kan de rechtbank het wenselijk
then the
achten
court shall declare
dat
the
de
writ of
verdachte
summons to be
bij
invalid.
behandeling
If
van de
the
zaak ter terechtzitting wel aanwezig
summons
is.
is valid, then the court may
In dat
find it
geval
desirable
kan de
that
rechtbank
the
bevelen
defendant is present
dat de verdachte in
at
persoon
trial.
zal
In
verschijnen.
that case, the court may
Kan de
order
rechtbank daartoe de
that the
medebrenging
person
van de verdachte
shall
gelastet.
appear in person and order the person to be brought before the court.
Ik zal nu ingaan op de stukken die per verdachte in
Now,
het dossier zijn opgenomen.
I will discuss the documents included in the file as of today.
De officier van justitie heeft een procesverbaal opgesteld
The
over de wijze van
prosecutor has
uitreiking van de
drafted an
dagvaarding
official
aan de verdachte
report
Girkin.
about how the writ of summons was
Girkin is
served
niet gedetineerd
to
in Nederland
defendant Girkin.
en
Girkin
is
is
niet
not in
ingeschreven
detention in the
in de
Netherlands and
Nederlandse
is
basisregistratie personen.
not registered in the
opsporingsonderzoek
key
is
register
verder
of
geen
persons in the
feitelijke
Netherlands,
verblijfplaats
nor has the investigation
opgegeven
revealed
postadres in
any
Nederland
address
voor
or place
Girkin
of residence or a mailing address in the
De
Netherlands for
rechtercommissaris
Girkin.
heeft een adres verstrekt aan de officier van justitie. waarop
The
Girkin volgens de
the
Russische
examining
federatie
magistrate
stond ingeschreven.
presented an address to the public prosecutor where Girkin
Die
is registered
informatie heeft de
according to the
rechtercommissaris
Russian
verkregen in het
Federation.
kader van
This
de
information was
uitvoering van een
provided to the
rechtsopzoek
examining
aan de Russische
magistrate
federatie
in the
om een brief
context
van
of
Girkin uit te
implementing an MLA to the Russian
Het opgegeven
Federation
adres is in
to
Moskou.
serve a letter to Girkin. The address
Met een
provided is in
rechtsopzoek
Moscow.
van 18 oktober 2019 is aan de Russische
In an
autoriteiten
MLA
verzocht
dated
om
18
de
October
dagvaarding
2019, the
in de
Russian
Nederlandse
authorities
taal
were
uit te
requested
reiken aan de verdachte.
to serve
Op
the
28 oktober 2019
writ of
is het
summons
rechtsopzoek
to
overhandigd aan de
the
Russische
defendant.
pakket van de
The
procureur-generaal.
summons was in Dutch and in Russian. On 28 October
Volgens het latere bericht
2019,
van de Russische pakket
the MLA
is dit verzoek
was
doorgezonden
presented
naar
to
de
the Russian Public
minister van Justitie.
Prosecution Service according to a later report. The Russian
Op 5 december 2019
from the Russian
is het akte
Prosecution Service, the
afgegeven aan de
request
griffier
was
van de
transmitted to the
rechtbank
Russian
in
Minister of Justice.
Op
On
29
5
januari
December
2020
2019, a memorandum was
ontving het
issued to the
Openbaar Ministerie
clerk of the
van het
court in the
Russische
Netherlands. On
ministerie van
29 January 2020, the
Het
Public
bericht dat het
Prosecution
verzoek tot de
Service received
uitreiking van de
word from the
dagvaarding
Russian
niet
Ministry
kon
of
worden uitgevoerd,
Justice that the
omdat
request
Girkin
to
niet was
serve
verschenen
the
op
writ
de
of
zitting
summons could
van de
not
Russische rechtbank.
be implemented because Girkin
Die
had not
rechtbank had
appeared
Girkin opgeroepen
before
voor
the
de zitting
Russian court.
op
That
30
court had
december
summoned
2019
Girkin
om 10 uur om stukken
at a hearing
aan
on
hem
30
uit te reiken.
December 2019 at 10 o'clock in the morning to serve him with documents.
Op 27 december
On
2019
27 December
heeft een
2019,
agent op het van Girkin
a
bekende
local
adres
police officer
wilde uitreiken.
tried to serve a document at the address known for Girkin, but
Volgens de
no one
buren van
answered
het
the door.
appartement
According to the neighbors
zou in het appartement
at the
waar Girkin
apartment,
ingeschreven stond een
at the
bejaarde
apartment
vrouw
where
wonen die
Girkin
nooit
was
de deur
registered,
opende.
an elderly woman
De dochter van de vrouw
lived
zou
who never
ook langskomen.
answered the door. The daughter of the woman was said to stop by occasionally. According to the neighbors, they never saw any men
Het
there.
is kortom voor de Russische en Nederlandse
So,
autoriteiten niet mogelijk gebleken
It has not been possible for the Russian and Dutch authorities to serve the summons to Girkin.
Het Openbaar
The
Ministerie
Public
heeft
Prosecution
hiernaast nog verschillende
Service
handelingen verricht
also
om Girkin
took
over de
various
strafzaak
steps
te informeren
to notify Girkin
om zijn
about the criminal
op de
case
beschuldiging te vernemen
or to hear his response
en
to the
hem in de
charge
gelegenheid te stellen
and
bij de
to
strafzaak
give him the
aanwezig
opportunity
te zijn.
to be present
Daarop
at
is
the
geen
criminal
enkele reactie
proceedings.
gevolgd.
No response at all followed.
Het Openbaar Ministerie heeft Girkin benaderd via accounts.
The Public Prosecution Service approached Girkin via accounts that the Public Prosecution Service suspected belonged to Girkin or were used
Zo
by
is
him.
gepoogd met hem in contact te komen.
They tried to contact him and notify him through Skype messages, email messages, and messages on a VK account. The information provided in the process includes that on 19 June 2019, a press conference would take place announcing that Girkin would be prosecuted, the opportunity to contact the JIT, referring to the site of the JIT, and that on 9 March 2020 at 10 o'clock in the morning, the criminal proceedings against him would start at Schiphol Judicial Complex in Bad Hoeverdorp, Netherlands. No response was received to these messages. At the press conference on 19 June 2019, it was announced that Girkin is being prosecuted for suspected involvement in the crash of flight MH17. His photograph was presented, and there was an announcement that his name would be placed on an international wanted list. This information was shared by Ukrainian Russian media. On the website of the Public Prosecution Service and the police, the press announcements with the same information were posted. On the date of the press conference in 19 June 2019, a message from the Interfax press service appeared, allegedly including a statement from Girkin. Girkin is said to have stated that he would not appear at the criminal case and that the militia did not cause the Boeing to crash and that the evidence against him was false and that he was not approached by the JIT. On the VK account suspected to be linked with Girkin, messages appeared that the separatists did not shoot down the Boeing, that Girkin was placed on an international wanted list, and that Girkin thinks he will not be extradited. Dutch media have reported that they were in touch with Girkin and that he supposedly said that he would not have himself represented and that he does not acknowledge the jurisdiction of the Dutch court. This is the official report about Mr. Girkin. The public prosecutor also drafted an official report concerning the manner of service of the writ of summons to Dubinsky. Dubinsky is not in detention in the Netherlands and is not registered in a Dutch key register of persons, and the investigation has not revealed any actual address or place of residence or mailing address in the Netherlands. And again, on 17 October 2019, the examining magistrate used an address on which Dubinsky was registered. According to the Russian Federation, the information was obtained by the examining magistrate in the implementation of an MLA to the Russian Federation to serve a letter to Dubinsky. The address presented was in Rostoy in the Russian Federation. In an MLA dated 18 October 2019, the Russian authorities were requested to serve Dubinsky with a writ of summons in Dutch and Russian. And this MLA was presented to the Russian Public Prosecution Service on 28 October 2019 and was transmitted to the Russian Ministry of Justice. On 5 December 2019, a memorandum was issued to the clerk in the Dutch court.
Op 19 februari 2020,
On 19 February
ontving het Openbaar
2020,
Ministerie
the
bericht
Public Prosecution Service received notice from the Russian
dat de verzoek tot dagvaarding
Ministry of Justice
niet
that
kon
the
worden uitgevoerd,
request to issue a writ of summons could not be implemented because Dubinsky had failed to appear twice
in Aksakij,
at
Rostov.
a hearing of the Russian court in Aksakij, Rostov.
Deze rechtbank had Dubinsky opgeroepen
This court
voor
had
een
summoned
zitting op
Dubinsky
24 januari 2020
to appear on 24 January 2020 and on 10 February 2020 to serve the documents to him.
De oproepingen om te verschijnen
The
zijn
summons
twee keer
to
naar het
appear
bekende adres gestuurd,
have been
en
sent
twee keer
to the
naar die
known
rechtbank
address
gerefereerd.
twice and returned
Van Dubinsky
twice
is geen andere feitelijke
to that court. No other
bekend geworden.
factual address or place of residence became known for
Ook
Dubinsky.
hier heeft het Openbaar Ministerie verschillende handelingen verricht.
Again, the
Dubinsky
Public
over de
Prosecution
strafzaak te
Service took
informeren,
various measures to notify Dubinsky
zijn
about the
reactie
criminal
op de
case,
beschuldigingen te vernemen,
to learn
minder
of his
gelegenheid te
response
stellen bij de
to the
strafzaak
charge and to give him the opportunity to be present at the criminal trial.
Het Openbaar Ministerie heeft
The
Dubinsky
Public
benaderd via
Prosecution Service
telefoonnummers
approached
en accounts
Dubinsky
waarvan het
via
vermoeden
phone
bestond
numbers and
bij het
accounts
Openbaar
that
Ministerie
the Prosecution
deze aan
Service
Dubinsky toebehoren
believed
of door
belonged
hem
to Dubinsky
gebruikt.
or are used by him.
Zo is gepoogd met hem in contact te komen
They tried to
en hem te
contact him
informeren
and inform
via
him
de telefoon,
via telephone,
WhatsApp-berichten,
via WhatsApp messages,
Skype,
Skype
berichten en Facebook-berichten.
messages, and Facebook messages.
En ook daarbij is de informatie verstrekt dat er op 19 juni
The
2009 een
information
persconferentie
provided
zou plaatsvinden,
included that
waarbij
there would
bekend
be
zou
a press
worden dat Dubinsky
conference
zou worden vervolgd.
on 19 June 2019 announcing that Dubinsky would be prosecuted, giving him the opportunity to contact the JIT and referring to the site of the JIT, and that on 9 March 2020 at 10 o'clock in the morning, criminal proceedings would start at Schiphol Judicial Complex here in the Netherlands against him.
Één WhatsApp-bericht is geopend op 19 juni
One
2019.
WhatsApp message was opened on 19 June
En een
2019.
link in een e-mailbericht op
And
19 december 2019 is geopend.
Link was opened to an email message on 19 December 2019. In addition, on 28 January 2020, a WhatsApp message was opened.
Daarnaast is op 16
In
januari
addition, on 16 January 2020, two telephone numbers were called which, according to the Public Prosecution Service, were previously used by Dubinsky. A connection was established twice with one of the numbers. A man answered the phone and denied that he was Dubinsky. After that, the calls were no longer answered. Two reporting officers believed that they recognized the voice of this man as Dubinsky's voice because they listened to several wiretaps in which Dubinsky is said to have participated. At the press conference on 19 June 2019, there was an announcement that Dubinsky is being prosecuted for suspected involvement in the crash of flight MH17. His picture was presented, and there was an announcement that his name is being placed on an international wanted list. This information was shared by Ukrainian and Russian media on the websites of the Public Prosecution Service and police. Press releases with the same information were posted. On 19 June 2019, Dubinsky was said to have stated to a reporter in The Guardian by WhatsApp that he had seen the charges of the JIT and that he did not intend to participate in the criminal proceedings. According to the Russian Ministry of Justice, on 8 October 2019, a letter from the Dutch examining magistrate was served to Dubinsky. Apparently, Dubinsky appeared in person before the Russian court. This letter read in part that Dubinsky would be prosecuted for involvement in causing flight MH17 to crash, and that in the preliminary investigation he could exercise his right to defense in person or via counsel. Those were the documents about Mr. Dubinsky. The prosecutor also drafted an official report about the manner by which the writ of summons was served to defendant Charchenko. Charchenko is not in detention in the Netherlands and is not listed in the Dutch key register of persons. The investigation has not revealed an actual address or place of residence or a mailing address in the Netherlands for Charchenko. On 17 October 2019, the examining magistrate provided the prosecutor with an address at which, according to the Ukrainian authorities, Charchenko was registered. The examining magistrate obtained this information in the context of implementing an MLA to the Ukrainian authorities to serve a letter to Charchenko. His address is in the Oblast Donetsk in Ukraine. This address is in the geographic area under the control of the Ukrainian authorities. According to the Ukrainian prosecutor, Charchenko apparently left the apartment at this address around 2014 and has not resided there since. There were said to have been various raids in the premises, and representatives of the Housing Association welded the door shut twice. On 22 October 2019, the Ukrainian authorities tried to serve a letter from the Dutch prosecutor at this address. The letter provided information about the criminal case against Charchenko and the decisions by the examining magistrate pursuant to 26A in the DCCP. This letter was inserted through a slit in the door and was left in the mail slot for that address. This letter also reflected information about the criminal proceedings and indicated that Charchenko was a defendant in this case, and the case would start on 9 March 2020. He was informed of his right to a defense.
Bij een op 12 november 2019 aan de Oekraïense officier van justitie overhandigd rechtsverzoek.
The MLA submitted on 12 November 2019 to the Ukrainian authorities. The Dutch ministry requested that the writ of summons be served to Charchenko in Dutch and Ukrainian. On 17 December 2019, it was served in that way by inserting a copy through the crack in the front door and leaving a copy in the mailbox. According to two witnesses that had been living in the complex for quite a while, Charchenko has not been seen there since 2014. He is said to have moved to Donetsk, and at that point in December 2019 was said to have been living in Horlivka. No specific address was stated there. On 5 December 2019, a memorandum was served to the clerk of the court in the Netherlands. The public prosecutor took various measures to notify Charchenko about the criminal proceedings and to learn his response to the charges and to give him the opportunity to be present at the criminal proceedings. The public prosecution service approached Charchenko via phone numbers and accounts that the prosecution service suspected belonged to Charchenko or were used by him. They tried to contact him and to notify him via WhatsApp, email, Facebook, and VK messages. These messages included a link to a site with information about the criminal proceedings. Log files revealed that a link was opened on 19 July 2019 at 15 hours 56 minutes on an Android device from an IP address in Donetsk. Upon opening, this information was revealed in English with information about the criminal proceedings with a link to the Russian translation of the website. On 20 July 2019, the profile photograph depicting Charchenko was removed from the account. On 25 October 2019, the account turned out no longer to be active, and on 14 January 2020, the account was no longer in use. Contact was also sought with Charchenko via VK Facebook accounts used believed to be used by his partner and his daughter. Those messages reflected the date, time, and place of the trial, plus a link to the writ of summons in Ukrainian. The link in the message to the presumed partner was not opened. The link sent to the presumed daughter was opened on 6 February 2020 from an IP address in Donetsk, in the Oblast Donetsk. On 19 June 2019, the Public Prosecution Service at a press conference announced that Churchenko would be prosecuted and announced that the proceedings would start on 9 March 2020 at Schiphol Judicial Complex here in the Netherlands. His photo was featured, and it was also mentioned that his name had been posted on an international wanted list. This information was shared by the international Russian and Ukrainian media. A press release in Russian was posted on the public prosecution website by the police. These are the documents mentioned in the record of the public prosecutor about the defendant Churchenko. So I have summarized the documents concerning the defendants Girkin, Dubinsky, and Churchenko relating to the service of the writ of summons. And I would like to ask the public prosecutor whether any additional is necessary to respond or whether the documents have been discussed in sufficient detail. Thank you. Based on the documents that I have now presented prior to the proceedings, the court has taken note of them. No additional documents have been added, and nobody is present to elaborate on the documents. That means that the court will need to base its judgment on these documents, and because the documents are all in the record, I've said that the court has reviewed them in advance, so I'm looking to my left and my right to see whether anything else needs to be mentioned. Apparently nothing else needs to be mentioned now. So based on those documents, the court has reached a decision about how to continue the case, and I will tell you that decision. And if we consider what has done regarding the defendants Girkin, Dubinsky, and Churchenko to serve the documents, and if we review that based on the prescriptions mentioned previously, the court notes the following: neither Girkin nor Dubinsky nor Churchenko is in detention in the Netherlands or has an address in the Netherlands. That means that the writ of summons need to be served to the clerk of the court, which took place on 5 December 2019. Because an address is known for them abroad, it's also necessary to send the writ of summons with a letter in a language known to the defendants via normal post abroad and via an MLA. The writ of summons and translation for Girkin and Dubinsky were included in the MLA from 18 October 2019 and were served to the Russian authorities on 28 November 2019. The writ of summons and translation for Churchenko were served in an MLA on 12 November 2019 to the Ukrainian public prosecutor. So it may be established that the writs of summons in the case against Girkin, Dubinsky, and Churchenko have been duly served. Next, the court needs to deliberate whether there are nonetheless reasons to suspend the case. Such a reason might concern the circumstance that upon submitting an MLA, certain treaty obligations, such as including a translation in the correct language and observing certain deadlines for between service of the MLA and the criminal proceedings have not been observed. The court notes that the writs of summons of Girkin, Dubinsky, and Charchenko included a translation in Russian and or Ukrainian. Regarding timely submission of the MLA, the court considers that the MLA requesting that the writ of summons be served to Girkin and Dubinsky was not sent directly to the Ministry of Justice and the competent authorities, but given the date that implementing the MLA started, which was 27 December 2019, serving the invitation to Girkin to come receive the writ of summons at a Russian court, it may be assumed that they were sent timely to the Ministry of Justice, i.e. over 50 days prior to today's hearing. As for the timeliness of sending an MLA to Ukraine to serve the writ of summons and translation to Charchenko, the court finds that this is dated 12 November 2019, so that this petition was sent in time, i.e. 40 days before the court proceedings. Another reason for suspending the proceedings might be the plausible situation that if it's plausible that the foreign authorities did not implement the MLA. The above reveals that that is not the case. Both Ukraine and Russia implemented the MLA. The circumstance that in none of the cases was the writ of summons served to the individual does not change that. The documents were served at the address where the defendants were registered. As for Dubinsky, there are strong indications that he actually resides at the address where he's registered. The Russian authorities have sent notice that on 8 October 2019, he did in fact fetch the letter from the Dutch prosecutor after having been summoned to appear on that date. So that would mean that he did in fact receive this letter. And this letter notes this criminal case and the charges against him, the suspected charges against him. As for Girkin and Charchenko, that's a different matter. In their case, there are no indications that they in fact received the writs of summons. Based on the statements from the neighbors, they may indeed not reside at the address where they're registered. Considering the different summons sent to Girkin, Dubinsky, and Charchenko through different channels, official letters, whether or not they were served in person, emails, messages via social media, websites, and press conferences, and the reactions from Girkin and Dubinsky, apparently, in the different media reactions via newspapers and social media, the court has no doubt that they are all aware of these criminal proceedings. In these circumstances, a suspect who might want to exercise his right to be present at criminal proceedings against him may be expected to make an effort to take note of the exact content of the charges and of the time and place where he is expected to present his defense against these
Dit
charges.
zou bijvoorbeeld kunnen door de autoriteiten te informeren over zijn
This
daadwerkelijke verblijf.
could involve notifying the authorities about his actual place of residence or mailing address, or
Nu de verdachte
by
Girkin,
sending legal counsel. Since the suspects Girkin, Dubinsky, and Cherchenko, despite knowledge of the criminal prosecution, have refrained from this, it may be assumed that they have waived their right to be present.
En nu ze zelf kennelijk geen waarde hechten aan het recht om
Since
aanwezig te
apparently
zijn bij de
they
behandeling van hun strafzaak,
do not attribute any value to the right to be present at the criminal proceedings, the court will allow
en in de zaken
the
tegen
due
Girkin,
process to
Dubinsky
prevail, and in the case against
verstek
Girkin, Dubinsky, and
en
Cherchenko,
de zaak tegen Girkin,
will try them in
Dubinsky en
absentia,
Cherchenko
and in the
kan
case
dus
against Girkin,
worden voortgezet.
Dubinsky, and Cherchenko, we will proceed.
Het staat de verdachten uiteraard vrij
Of
om
course,
bij
the
de verdere behandeling
suspects
van hun
are
strafzaak
free
op een later moment
to
alsnog aanwezig te zijn.
be present at a later point
Het verstek
during
wordt
the
dan
criminal
geheeld.
proceedings.
Het proces zal dan alsnog
The
in tegenspraak
absentia will then
worden
be
voortgezet.
rectified, and the procedure may then be continued as an adversarial procedure.
De mogelijkheid om te bevelen
And the court
dat de verdachte in persoon zal
offers the
verschijnen
option to order that the
de
person
mededeling
appear
van de
in
verdachte te gelasten.
person and to order that the person appear before the
De
court.
rechtbank zal daartoe echter niet
However,
overgaan,
the
omdat
court
dat
will
niet zinvol
not
vindt.
proceed to doing this, since this does not
Precies
seem
wat blijft uit.
meaningful
De verdachte is
or
onbekend.
sensible. The exact place of residence of these suspects is unknown. In addition, they are believed to reside
Onderdaan betreft
in a country
mag of niet zal
that
uitleveren.
is unable or will not extradite its own citizens.
En na deze vaststellingen en beslissingen van de rechtbank
After these observations and decisions by the court,
dat het Openbaar Ministerie
it's
de
time
zaak kan voordragen.
for the Public Prosecution Service to present the case. And although we just had a break and it's now almost noon, I believe it's time to attend this presentation. After the presentation, we will have a break. Please go ahead.
On 17 July 2014, Malaysia Airlines flight MH17 was shot down in East Ukraine. The crew and passengers of flight MH17, in total 298 persons, all lost their lives. And more than one country in the world, namely Australia, Belgium, Canada, Germany, the Philippines, Indonesia, Israel, Italy, Malaysia, the Netherlands, New Zealand, Romania, the United Kingdom, the United States, Vietnam, and South Africa all mourn for the demise of their citizens. Today, the criminal proceedings against 4 defendants start: Igor Girkin, Sergei Dubinsky, Oleg Pulatov, and Leonid Kharchenko. In the opinion of the Public Prosecution Services, they organized that around 17 July 2014, a deadly weapon, a Buk Taylor, was transported to East Ukraine, as well as arranging that said Buk Taylor was brought to a location from which a Buk missile was launched, which missile hit said flight MH17. Subsequently, they also saw to it that the deadly weapon was returned. All 4 defendants have been summoned on the suspicion of, first, to cause flight MH17 to crash, resulting in the deaths of all occupants, a criminal offence under section 168 of the Dutch Criminal Code, and second, the murder of 298 occupants of flight MH17, a criminal offence under sections 289 and 287 of the Dutch Criminal Code. Both these criminal offences were charged against the defendants in 4 alternatives. Principally, having acted as co-author in an organisation context, alternatively, having participated in the commission of a defence, or alternatively, having participated in the instigation of a aforementioned criminal offence, and final alternative, having participated in the complicity in aforementioned criminal offences. The consequence of the actions of the defendants was the death of
Wan Amran Binwan Hussein, Eugene Chujin Leong, Ahmad Hakimi bin Hanapi, Muhammad Firdaus bin Abdul Rahim, Muhammad Ghaffar bin Abu Bakr, Dora Shahila binti Qasim, Azrina binti Jacob, Li Hui Pin, Mastura binti Mustafa, Eve Chong Yi Peng, Sheikh Mohammed Nur bin Mahmud, Sanjit Singh Sandhu, Bobby, Hamvaslin Sham Mohammed Arifin, Nur Shasana binti Mohammed Saleh, Angelina Premila Rajandran, Liam Patrick Davison, Francesca Louisa Davison, Ong Queen Cheng, Jan van der Steen, Cornelia Vooram, Frederike van Zijtveld, Robert Jan van Zijtveld, Tim Nieburg, Sascha Rosemarijn Meijer, Victor Oreshkin, Shaka Tamaputra Panduwinata, Miguel Kiasi Panduwinata, Tami Tamsanka Uiterlinde, Yvonne Kappen, Tess Trug, Liv Trug, Remco Trug, Leon Wels, Connie Wels Stuiver, Sam Wels, Li Kia Yin, Liu Yao Chi, Charles Louise Smallenburg, Carlijn Willemijn Smallenburg, Werther Vlaanderen Smallenburg, Therese Marie Elisabeth Smallenburg Brouwer, Tamara Adriana Ernst, Emiel van Muilwijk, Adinda van Muilwijk, Vicky van Muilwijk Cardia, Paul van der Sande, Suzanne Heijmans, Steven van der Sande, Tessa van der Sande, Alex Ploeg, Edith Ploeg Kuipers, Robert Ploeg, Robin Hemelrijk, Helena Maria Siedelik, Rob van Keulen, Carolien van Keulen van Doorn, Allard van Keulen, Jeroen van Keulen. Nguyen Ngoc Minh, Dang Minh Chau, Dang Quoc Thuy, Henk Kroon, Ina Kroon Broghammer, Gerardus Frederik Menke, Mary Elisabeth Menke, Cor Schilder Pan, Neeltje Tol, John Paulussen, Julie Hastini, Arjuna Paulussen, Sri Paulussen, Lian Derden, Joep Lange, Jacqueline van Tongeren, Lucie van Mens, Glenn Raymond Thomas, Martine de Schutter, Pim de Kuijer, Henry Ung, Jan Norelde, Annemieke Mignon Hakse, Steven Norelde, Klaas Willem van Luik, Henk Tournier, Ineke Tournier Westerveld, Christine Markelbach de Sadeleer, Antoine van Veldhuizen, Simone Markelbach van Veldhuizen, Quint van Veldhuizen, Pijke van Veldhuizen, Erik Peter van Heiningen, Tina Pauline Mastenbroek, Zeger Leonard van Heiningen, Supartini, Richard Franklin Main, Michael Martin Clancy, Carol Ann Clancy, Marco Grippeling, Andrew Hoare, Estella Hoare Vermeulen, Jasper Hoare, Friso Hoare, Tan Siu Po, Fan Shun Po, Lo Yanhua, Paul Goes, Subhashni J. Retnam, Kaela Maya J. Goes, Itamar Afnon, Tammy bin G, Ariza binti Ghazali, Mohammed Afif bin Tambi, Mohammed Afsal bin Tambi, Marsha Azmina binti Tambi, Mohammed Avrus bin Tambi, Ben Pocock, Regis Robert Corolla, Ingrid Maya Meijer, Sophie Charlotte van der Meer, Fleur Isabelle van der Meer, Bente Willemijn van der Meer, Oscar Kotte, Remco Kotte, Miranda Kotte Smolders, Talander Franciscus Niewold, George Pijnenburg, Christy van den Schoor, Gijsbert van Duin, Inge van der Sar, Peter Soeren, Janneke Nelissen, Priya Kausalya Jairamdas Punjabi Vijendran, Gust Moors, Toos Moors Ruiter, Lorenzo van de Kraats, Rob van de Kraats, Barbara de Bruin, Huub van Vreeswijk, Eline Marieke Franks, Jeroen Renkers, Karen Honakker, Tim Renkers, Jeroen Wals, Brett Wals, Jinte Wals, Amel Wals, Solen Wals, Nicole Wals Martens, Roger Gard, Jill Gard, Harry Wagemans, René van Gene, Daisy Reisa, Howard Ramon Horder, Susan Merlin Horder, John Lahey, Lilian Brouwers, Theo Kamsma, Karen Bras, Quo Kamsma, Sergio Paulo Otokjan, Esther Otokjan de Ridder, Julian Tiamo Otokjan, Elsemiek de Borst, Christopher Allen, Sandra Ellen Martens, Ian Allen, John Allen, Julian Allen, Hasni Hardy Parlan, Jack Samuel O'Brien, Bart Lambrechts, Astrid Hornix, Stephen Leslie Anderson, Hanny Huntjens, Erik Vleesebeek, Lieke Gianotte, Daisy Joe Oelers, Bryce J.C. Frederiks, Gabrielle Gabi Lacher, Hadiono Budianto Gunawan, Irene Kabili Gunawan Pavillon, Daryl Dwight Gunawan, Cheryl Shania Gunawan, Rishi Vinishkumar Jinku, Nisha Natasha Sabita Devi Jinku Binda, Joop Albert de Roo, Auke Dalstra, Aafke Dalstra de Vries, Siti Amira Binti Parawira Kasuma, Ninik Yuriani, Donny Tukiran Jody Kromo, Annelene Rostiem Misran, Maarten de Vos, Cameron Douglas Delziel, Willem Witteveen, Litwien Heerkens, Marit Witteveen, Arjen Ryder, Yvonne Ryder, Saskia Maria de Leeuw, Rick Schuismans, Paul Sivaknenam, Mabel Susai Sivaknenam, Matthew Ezekiel Sivaknenam, Willem Grootscholten, Mohammed Ali bin Mohammed Salim, Dave Helly, Kim Helly Verhaag, Megan Helly, Nickel Charles Anderson Norris, Mo Maslin, Evie Maslin, Otis Maslin, Geert Timmers, Hanny Timmers de Haan, Lisanne Laura Engels, Emiel R. Mahler, Elaine Cho E. Ling, Frank van der Weijden, Helen Borgstede, Karamjit Singh Karnel Singh, Robert Ely, Peter Essers, Jolette Nusink, Emma Essers, Valentijn Essers, Noor Rahima Tournier Binti Mohammed Noor, Rijn Spekken, Desiree Zandkuil, Anton Kamferman, Lianne Kamferman Jansen, Albert Risk, Marie Elizabeth Risk, Wayne John Baker, Theresa Jennifer Baker, Hilkje Raap, John Alder, Liam Sweeney, Adele Mahadi, Hans van den Hende, Shalisa van den Hende Jiwa, Piers van den Hende, Marnix van den Hende, Margot van den Hende, Mary Philomeen Tjernan, Pieter Jan Willem Huibers, Hanna Sophia Meuleman, André Marius Angel, Olga Ioppa, Quinn Schansman, Robert van der Linde, Erla Palm, Merel van der Linde, Mark Onno van der Linde, Gerda Liliana Lahenda, Jane Madeleine Adi Suchipto Kraai, Wouter Johannes Wilhelm Vorselman, Jeroen van de Mortel, Winneke van de Mortel van Wiggen, Milia van de Mortel, Kevin Jesrun, Wayan Sujana, Benoit Chardon, Erik Maas, Petra van Eldijk, Emma Marie Bell, Barry Arden Jan Willem Kooijmans, April Antigone Kooijmans van Doorn, Mira Elise Kooijmans, Isa Emee Kooijmans, Daphne Janne Niveen, Ung Shi Ing, Benjamin Lee Jan Han, Elisabeth Ong Lie T, Ketut Priscilla Martini, Jennifer van der Leij, Rowan Bats, Truike Heemskerk, Erik van der Poel, Joyce Baai, Wim Bakker, Annette de Jong, Charles Eliza David Tamtelahitu, Waikyong Gary Lee, Mona Chengsim Lee, Meling Anak Mula, Stefan van Niele, Esther de Waal, Arnoud Huizen, Odi Huizen Titialawa, Jelena Clarice Huizen, Carlijn Keizer, Laurens Pieter van der Graaf, Fu Ming Lee, Petra H. van Langeveld, Gary L. Slok, Fatima Dijinski.
Mevrouw de officier, dank u wel voor deze voordracht.
Yes, thank you very much for that presentation.
Ik zei zojuist al bij mijn inleiding dat...
I said during my introductory statement this morning, says the presiding judge, that the consequences
deze zaak over gaat,
of what happened in this case, the impact of next of kin, is almost inconceivable.
hier in deze zaal,
And the
bij alle aanwezigen,
heavy silence in this room when the names were being read out of all those people who lost their lives makes abundantly clear
na deze voordracht eigenlijk alleen stilte en bezinning.
that everybody is sitting here lost in their thoughts.
nu onderbreken.
So we shall now adjourn,
Verder te gaan en we zullen onderbreken tot 12:30.
and we shall adjourn until 1:30, and then we shall continue as of 1:30. Thank you.
Well, numbers like these brought women across the region onto the streets to take part in protests that often became violent. Protesters in Chile clashed with police and faced tear gas and water cannon in the capital Santiago. There were similar scenes in Mexico City, the capital of a country where on average more than 10 women are killed every day. Buenos Aires saw peaceful protests as people gathered